This report today may seem to have a somewhat academic and uninteresting title because I called it Civil Rights in the Legislative Process. Now that may be very forbidding, but I think we'll get around to it in a little while, and it's been on my mind for some little time. You see, there have been so many letters. Our mail runs about 2,000 letters a day now, and half of those are on civil rights. But that's not the whole story. We get delegation after delegation from all over the country. And I'm sorry that the columnists and others seem to impute to me some influence and powers over this civil rights measure pending in the Senate that perhaps I do not possess, and it seems just like an overabundance of flattery. But in any event, these delegations come from Illinois, New York, Maryland, New Jersey, Ohio, just anywhere and everywhere. And sometimes they get a little imperious. By that I mean this. They say, we demand that this House bill that came to you from the House of Representatives be enacted by the Senate without change. Others, of course, will entreat you, some will hope, some will request, but in the letters they just demand, and on occasions in person they demand. And I simply have to say to them, I'm sorry, but I'm a legislator. I have to deal with words that go on paper that become law and apply to the whole country. And ultimately, those words will be interpreted by a federal commission or by a United States court. And I must be very careful about this to make sure that what we do is practical, that it's workable, that it's equitable, and that it's fair to all people. You see, and it's a little difficult to make them fully understand. But that's the case, and so I thought it would be timely to refresh you just a little on the legislative process. Our basic law, our Constitution, is the organic law on which our country rests. And in it, it recites expressly that a bill must be approved by both branches of the Congress before it goes to the President, either for his veto and disapproval or for his approval and signature. And so that's a balance in this government. Now the Senate, it consists of 2 senators from every state. Rhode Island hasn't got as many people as there are in one good-sized county in Illinois, but they've got 2 senators. We have maybe 10.5 million back home. We have 2. On the House side, of course, we have a lot more congressmen. Rhode Island has only 2. Some states have only 1. They're selected on the basis of population, but that's the balance. And so both bodies have to join in the enactment of a legislative proposal before it can start toward the White House for the President's examination and approval or disapproval. Now then, bills are introduced and can be introduced by anybody. In the House, only one person can attach his name to a bill. In the Senate, not only 2, 3, or 4 senators can do it. I've seen bills where 80 senators have joined in a bill. And when it's introduced, it's referred to the appropriate committee. Does it deal with agriculture? It goes to the Agricultural Committee. Does it deal with matters like civil rights and the courts? It goes to Judiciary. Does it deal with taxes and tariffs? It goes to the Finance Committee. And in the committees is where the work is done. There they hold the hearings. They hear witnesses. Then in executive sessions they mark up the bill. Amendments are offered. Changes, modifications take place. Then it's either reported or it's put in a pigeonhole. If it comes to the Senate calendar, then it's up to the Administration Policy Committee and to the Majority Leader to motion up the bill. And he'll do that whenever he thinks the time is right. When it gets to the calendar, he'll usually confer with me about it. And I have to see whether our members on the committee will be available on that given date when the bill comes on for action. Now we go through the amending process in the Senate all over again. Doesn't make any difference what the bill is. It can be amended under Senate rules. And many bills are amended in great detail, sometimes to the point where the original authors would hardly recognize their original brainchildren. But that's the legislative process that I speak of. And it obtains not only in the Senate, but in the House as well. See, each body is a judge of its own rules under the Constitution. But the procedure for the development of a bill is about the same in the House and in the Senate, except we have one calendar in the Senate. In the House they have 4, depending on the type of bills, and probably due to the fact that it's a larger body with 435 members as distinguished from 100 senators. Now, when a bill has negotiated both House and Senate, there's still a third house. That's what they sometimes call it. That's the conference committee. You see, if a bill is amended, why, there's a disagreement between the two bodies. So it's got to go to a conference committee made up of maybe half a dozen senators from both House or Senate and House, representatives and senators, and they sit around and try to patch up these differences. Sometimes they may have a dozen conferences. Sometimes they disagree violently about it. But until they compose their differences and set it out in a conference report, nothing can happen to that bill. It's just stalemated. But those conference reports have to come back for second action by the House and Senate, and once that agreement is reached, then your bill is enrolled on parchment, signed by the President pro tem in the absence of the Vice President, and by the Speaker, and then it goes to the White House for signature. Now, let's look at this process in connection with civil rights. It was June of last year when President Kennedy sent his message, and there were only 7 titles to that bill. The bill that's before us now has 11 titles. Quite a difference. There was no Fair Employment Practices Commission in the President's bill. He told me on at least 4 occasions at the White House that he didn't propose to include it in the bill. I do not believe the Attorney General is very happy about it. But see, that was put in the House of Representatives. Other things were written in. As a matter of fact, there were scarcely any committee hearings on the bill now before the Senate. And at long last, when it got to the House floor in the legislative process, there were 155 amendments offered. Think of it. 34 of them were adopted. Now, under their rules, you can only get 5 minutes to discuss an amendment, except by special consent. 5 minutes for an amendment, 5 minutes after. And then by pro forma procedure they have, others can talk on it. But it's limited, and you don't always get the best consideration of amendments, and particularly those that are far-reaching in character. So here were 155 amendments. 34 went into the bill. And when it was passed, a messenger came to the Senate door. He was recognized by the man occupying the Vice President's chair, and said, a message from the House of Representatives. House has passed the Civil Rights Bill. The concurrence of the Senate is requested. But you see, everybody was alert to what was going to happen, so the bill was intercepted at once, and they called it up for first reading. Under the rules, you can do that, and you read a bill by title. Also, the second time it's read by title. It's before the third reading when the business really begins, and you have to perfect the bill. So this bill was intercepted, and couldn't get it to committee because there weren't votes enough. So it went on the Senate calendar, and there it was, subject to call by the majority leader. So that's the bill that is before the Senate. Now, when they say to me, we demand that you pass the House bill as it is, without any change, I have to say, you forget the legislative process. The Senate is a part of the legislative establishment, and as such, no bill can ever go to the White House unless both bodies agree finally on its content. And would you have the Senate suddenly pick up its ball and bat and go home and say, very well, if that's it, there's no use of us being around here. We can't refine the bill. Why, the very purpose of our balanced government and our bicameral two chambers system is to make sure that everything is very carefully considered and carefully refined, and then to go to the third house, the conference committee, and make the conference report come back. And then you feel pretty sure that you've done a pretty fair job in the legislative field. As I said, what we do is going to have to be interpreted by a federal commission. Suppose it's not a good piece of workmanship, then what? Suppose a man is hailed into a federal court, and here are words that the judge doesn't understand, or they don't make sense to him particularly, or it's imperfect in some particular. Then what? Well, you could conceivably send him to jail. And you don't visit punishment upon people in a free country without doing it fairly and equitably, because that's the hallmark of all of our institutions and our whole system of government. Now, to give you just one example, I have 10 amendments appending to one title on this bill when I get around to them. I add only 2 words to one section, hiring halls. Why? Because in defining an employment agency which is affected, they didn't mention hiring halls. Well, in the maritime industry, the shipping industry, in the fruit areas, you have hiring halls, and a contractor, somebody wants men. He calls up the fellow who runs the hiring hall. Send me so many. Why, it's at that point where the discrimination can take place. And 7% of all the discrimination cases under the Illinois law in 1963 related to hiring halls. You see what I mean? I want it in this bill. I want the word willful in there when a man gets into court, because discrimination could be unintentional. It could be inadvertent. It could be accidental. Do you punish him for something accidental or unintentional? Certainly not. And by putting in the word willful, the court has to find that his discrimination was willful, and when it does, you see, then of course, he has no further plea, and you could punish him if it was a willful discrimination. Now, those are only 2 words, think of it. But look at the significance of a word here and a word there. So the legislative process, it calls for action, refinement by the Senate as well as by the House. And that's the process we're in now. And that's the answer to those who would demand that we pass the House bill out of hand without any changes. It's good to visit with you.